Hello, good evening, and welcome to Unacademy. Welcome to the penultimate session of the last lap. In this session, let's quickly revise all the important articles of the Indian Constitution relevant for the upcoming Prelims 2024. But some of you might be wondering, what is the significance, what is the utility of this session? I will briefly take you through some of the questions which have appeared in the prelims examination over the past few years, and then on your own you will find an answer to the question that you have on your minds about what is the utility, what is the significance of this session. Let's get started and look at the question which appeared in Prelims 2021. Right to privacy is protected under which article of the Constitution of India? And you are aware, in a landmark case, Swamy judgment, the Supreme Court, 9-judge bench of the Supreme Court said a right to privacy is a fundamental right under Article 21 of the Constitution. See the kinds of questions that have been asked in the prelims examination. Let's look at another one. Which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Untouchability is mentioned under Article 14 of the Constitution. If you look at right against exploitation, it covers Articles 23 and 24, right to freedom, Articles 19 to 22, right to constitutional remedy, Article 32 of the Constitution, and right to equality covers Articles 14 to 18, which means it is in this category, right to equality, that untouchability as a form of discrimination has been abolished. Most of the students made an error while answering this question. They thought since untouchability is some form of exploitation, so it might have been covered under right against exploitation. But the answer is D, right to equality. Clear? Which of the following are envisaged, and this was the question asked in 2017, by the right against exploitation in the Constitution of India? Right against exploitation, I told you previously, is under Article 23 and Article 24. Article 23 prohibits traffic, begar, and other forms of forced labor. Article 24 talks about prohibition of employment of children in hazardous industries and occupations. So prohibition of traffic in human beings and forced labor, prohibition of employment of children in factories and mines and other hazardous occupations. Abolition of untouchability is under Article 17. Protection of the interests of minorities is under Article 29 as well as Article 30. So 1 and 4, C is the right answer. And now I think you may be aware of the kinds of questions that can be asked from this session that we are carrying out today. Let's look at another question. This question was asked in 2019. Which article of the Constitution of India safeguards one's right to marry the person of one's choice? Listen to me carefully. Right to marry is not a fundamental right. Who said this? Supreme Court in Suprio versus Union of India. When? In 2024. But in 2019, in the famous Hadia case, the Supreme Court had said that right to marry is a fundamental right under Article 21 of the Constitution because it's an important facet of right to life and personal liberty. But now it is not a fundamental right. A legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution? That is Article 14. Right against arbitrariness is a fundamental right under Article 14 of the Constitution. Clear? Article 20, this question was asked in 2021. Under the Indian Constitution, concentration of wealth violates what? It violates directive principles of state policy. Article 39, Clause C. The operation of the economic system and the means of production should not result in the concentration of wealth to a common detriment. See the kinds of questions asked. What is the position of right to property in India? It used to be a fundamental right till 1978, but it was the 44th Constitutional Amendment Act 1978 which removed right to property as a fundamental right, and now it is a constitutional right under Article 300 capital A. So it is a legal right available to any person. Clear? Right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Right to privacy, Supreme Court has said, is a fundamental right under Article 21. All these fundamental rights are mentioned where? They are mentioned under Part 3 of the Constitution. So what do you think is the right answer? Article 21 and the freedoms guaranteed in Part 3, C, is the right answer. Let's look at something else, 2019, and I will end it here. With reference, not the class, the answer to your question, what is the utility, what is the significance of this session, why should we attend it? With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following? And Article 142, I'm sure all of you are aware of. It is the power under which the Supreme Court has the power to issue any order, judgment, direction, so as to give complete justice. So it is not a power available with the Election Commission. It has nothing to do with the financial emergency. It has got nothing to do with state legislatures making laws on certain matters. It is the power of the Supreme Court under Article 142. Clear? Now let's crack it. And today I will not ask you to like this video or drop in your comments. Forget about it. Focus on your class. Focus on your revision. All the best. Let's crack it and start with the topic. Let's revise all the important articles one by one. Article 1, and listen to me carefully. Article 1 has 3 clauses. Article 1, clause 1 says, India, that is Bharat, shall be a union of states. That means we have 2 names for this country, dual name, India and Bharat. And Dr. Ambedkar has said, I have used the term union of states and not federation of states because of 2 reasons. Why? Because India is not the result of an agreement between states, and no state has the right to secede from the Union of India. So Article 1, Clause 1 says, India, that is Bharat, shall be a union of states. Article 1, Clause 2 says, the names of the states and territories thereof shall be specified where? In the first schedule of the Constitution. And then the third clause says, the territory of India shall comprise of either we can have states or we can have union territories or we can have acquired territories. That's what Article 1 talks about. Which of the articles of the Indian Constitution talks about the territory of India? Article 1. Article 3, it talks about the formation of new states. For example, Parliament has the power to increase the area of a state, to decrease the area of a state, to alter the boundaries of the state, to change the name of the state, to bifurcate the state, to split states into multiple different states. What happened in Andhra Pradesh, for example, what happened in Jammu and Kashmir, for example. That's the power given to Parliament under Article 3 of the Constitution. And remember, you should also revise what is the consultative process that the government has to follow when it comes to Article 3, when it comes to what is known as the reorganization of states. Clear? Let's look at another segment. Normally, I would tell my students, don't memorize, don't remember the articles under Part 2 of the Constitution, which deals with citizenship. But this year is an unusual year. In a sense, in this year, we saw citizenship amendment rules were notified by the government. There is already a petition pending before the Supreme Court challenging the constitutional validity of CAA 2019. The Supreme Court has already heard the arguments and closed the arguments on Section 6, capital A of the Citizenship Act 1955, which gave some sort of a different status to Assam. In a sense, you would know about that. The cutoff date for citizenship in Assam is different from the rest of the country. All these matters put a spotlight on Part 2 of the Constitution. Maybe in match the following type questions, Article 5 to 11 can be important for your exam. Article 5, it talks about citizenship at the time of the commencement of the Constitution. So, on 26 January 1950, who could have been the citizen of India? Who was born on the soil of India? Who has ordinarily resided in India for 5 years? Such were the conditions that you are the citizen of India. So Article 5, remember, talks about citizenship at the time of the commencement of the Constitution. Article 6 talks about rights of citizenship of certain persons who have migrated to India from Pakistan. Listen to me carefully. The country was partitioned into India and Pakistan. And there was a massive migration of people as well from both sides, from India to what became Pakistan, from Pakistan to India. All those who migrated from Pakistan to India before 19th of July 1948, they are the citizens of India. So Article 6 talks about rights of citizenship of certain persons who have migrated to India from Pakistan. So those who came from Pakistan to India, if you have entered India on or before 19 July 1948, you are the citizen. But what if you have entered India after this date? Then you have to register for citizenship. And this is where the kind of permit system was introduced by the government. So after this date, not everybody would get the citizenship. Only those who are permitted by the government of India, they will be granted citizenship. Why? We have discussed that previously, why, in our classes as well. Article 7, rights of citizenship of certain migrants to Pakistan. Whoever migrated from India to what became Pakistan after 1st of March 1947, those are not the citizens of India. So whoever has migrated from India to Pakistan after 1st March 1947, you are not the citizens of India. But it is this Article 11 which gives unfractured power to the Parliament, that you can make all laws regulating the citizenship. And that is how the Parliament enacted a law. And which is that law? The Citizenship Act of 1955. And it is this Citizenship Act 1955 which has been amended multiple times, and as recent as 2019, which is what is known as the Citizenship Amendment Act 2019. So Citizenship Amendment Act is basically an amendment to the Indian Citizenship Act or the Citizenship Act of 1955. Clear? Let's look at the next slide. And here is an announcement for you. Those appearing in 2025 or onwards. And if you are thinking, contemplating, and if you want guidance, coaching, live classes, then please consider us. If you're satisfied with our quality, I can claim that we provide the top quality content, but it is for you to judge. Some of you may be appearing for 2025, and if you are desirous of seeking these live classes, then seek them now, because this time the course fee has been reduced massively. After the prelims examination, the course fee is going to be increased massively. So if you are considering, consider now. I'm not forcing you, but if you are considering, consider now, because this time you can get a 15-month subscription for less than 30,000. Let's get started and let's look at another important. Vijay has predicted something. Article 12 and 36, Part 3 of the Constitution, which talks about fundamental rights. Part 4 of the Constitution, which talks about directive principles of state policy. Now, in both these parts, there is a mention of state. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. So these fundamental rights are basically negative obligations on the state. But when it comes to directive principles of state policy, these directive principles of state policy, these are positive obligations on the state. The state is being asked to interfere. Please interfere so that we can minimize the gulf between the rich and the poor. But what is the definition of the state? That is provided under Article 12 for Part 3. That is provided under Article 36 for Part 4. And the definition is same. Maybe a statement can be asked in the examination. The definition of the state under Part 3 and the definition of the state under Part 4 are not the same. Which of these statements is or are correct? So in those types of questions, this can be an important statement. Now Vijay asked something, does the definition of state include judiciary? There's a lot of debate on that. It is inconceivable. Why? What is inconceivable? That judiciary, which the Constitution has tasked to uphold and protect the fundamental rights of the citizens, is capable of violating the fundamental rights. So what are we saying? Under fundamental rights chapter, under Part 3 of the Constitution, state appears. The state cannot do this, the state cannot do that, the state cannot do this. That means there are limitations on the state. That means if the state violates fundamental rights, drag the state to the Supreme Court under Article 32 of the Constitution. So it is inconceivable that an institution, judiciary, which is meant to protect your fundamental rights, can also violate your fundamental rights, can also be the usurper of your fundamental rights. That is why judiciary is not considered as a state under Article 12. But judiciary has the administrative side as well. That administrative side comes under Article 12, but not the judicial side. Clear? Very good. Article 14, which is applicable to citizens as well as aliens. It says the state shall not deny to any person equality before law or equal protection of the laws within the territory of India. But I'll tell you two more extra statements here. And listen to me carefully. This I think can be asked in the exam. Can be. Right against arbitrariness is a fundamental right under Article 14. But one more thing. Right against the adverse effects of climate change. The Supreme Court has said this recently. It is also a fundamental right under Article 14 as well as under Article 21. So just like the question was asked, right to privacy is contained under which of the following articles? Right to privacy is an integral part of right to life and personal liberty, which means what? Similarly, right against adverse effect of the climate change is a fundamental right under which of the following articles? Article 14 as well as Article 21 of the Constitution. Clear? Article 17, it says untouchability. And remember, this term untouchability is in quotes, which means this term is not defined in the Constitution. And when we say Article 17 says untouchability is abolished, it does not define what is this untouchability. That means we are not looking at the literal meaning of the term untouchability. We are referring to the historic practice of untouchability as was practiced after the later Vedic period. That form of untouchability is abolished and its practice in any form is forbidden. That's Article 17 of the Constitution. For that we have Protection of Civil Rights Act, which was passed in 1955, but then we have the Atrocities Act of 1989. Clear? Very good. Let's look at Article 19 and listen to me carefully. Article 19 protection of certain rights regarding freedom of speech. But you might have heard of Article 19, Clause 1, Clause A. It is this Article 19, Clause 1, Clause A, which talks about freedom of speech and expression. And this has been in the news. If you look at the electoral bonds judgment, what did Supreme Court say? As a voter, we have the right to know the antecedents of the candidates contesting the election. What is your educational qualification? How many criminal cases are pending against you? How many assets are in your name and in the name of your spouse? That Supreme Court said in an old judgment. But in the electoral bond judgment, in another ADR case, the Supreme Court said, using this logic, the citizens also have the right to know the funding of political parties. Who is funding whom? Otherwise, there is quid pro quo. We've explained that judgment in one of the nuanced series as well. If you haven't watched that lecture, don't watch it now. Watch it after your prelims examination. But long story short, Article 19(1)(a), it talks about freedom of speech and expression. And under this, we have number of inferred rights. And one such inferred right is seeking information. That is what we call right to make an informed choice. Right to make an informed choice is fundamental right under which of the following articles? Clear? That's Article 19(1)(a). And then we have Article 19(1)(b), 19(1)(c), 19(1)(d), 19(1)(e), 19(1)(f) got omitted because of the 44th Constitutional Amendment Act, then 19(1)(g) as well. So right to assemble peacefully without arms under 19(1)(b), right to form unions, associations and cooperative societies, right to move freely throughout the territory of India, right to reside and settle anywhere within the territory of India, right to take up any trade, occupation and profession. These are the natural rights that are mentioned under Article 19 of the Constitution. Clear? Very good. Article 21, protection of life and personal liberty. No person shall be deprived of his life and personal liberty except according to the procedure established by law. And we know it's basically due process of law. As ruled by the Supreme Court in the Maneka Gandhi case, 1978. And Supreme Court also said, we follow the principles of natural justice. Although every single civil services aspirant would know what Article 21 is, but if I would have skipped this article, you would have said, sir, what are you doing? The most important article under the fundamental rights you are skipping. So Article 21, right to life and personal liberty. And it is through this article, we would say, what is the significance of this article? If there was no right to life, all other fundamental rights would be meaningless. Let's say when in 2016, Prime Minister Modi addressed the nation and said, Mitro, from midnight, all the 500 and 1,000 denomination notes would cease to remain a legal tender. That means demonetization was announced. Now, if you had these 500 or 1,000 denomination notes, what you could do, you could get them exchanged. Otherwise, these are worthless piece of paper. If there was no Article 21, all these fundamental rights would have been just worthless piece of paper. In a sense, you can't enjoy these fundamental rights if you don't have right to life. Clear? And that is why Article 32 also becomes important. Because Dr. Ambedkar said, let's look at Article 32 here. Dr. Ambedkar said Article 32 is the fundamental of all fundamental rights. Because without Article 32, because what is Article 32? If your fundamental rights are violated, you can drag the state to the Supreme Court under Article 32. and it is mentioned in the Constitution. What is mentioned in the Constitution? Maybe you are asked, are these writs of habeas corpus, mandamus, prohibition, certiorari, quo warranto mentioned in the Constitution? Yes, they are under Article 32. And this right to a remedy, that in case your fundamental rights are violated, you can approach the Supreme Court. Even this remedy itself is a fundamental right. That's the beauty of Article 32. And Dr. Ambedkar said if there was no Article 32, the entire Constitution would have been a nullity. But be that as it may, I'm sure you are aware of this. That is Article 21. Now look at Article 25. Look at Article 25. It begins with restrictions. Subject to public order, subject to morality, subject to health. You may be asked about what are the restrictions on the freedom of religion. Restrictions are on the grounds of public order, morality and health, and subject to other provisions of Part 3 of the Constitution. Everybody, whoever is residing in India, which means including foreigners, they have the fundamental right to religion. That means they have the freedom of conscience, freedom to profess, practice, and propagate the religion of your choice. But that does not include right to convert others into your religion. This is not a fundamental right under Article 25. So restrictions on Article 19(2), please revise them. Article 19 is not an absolute fundamental right. Let's say Article 19(1)(a), which talks about freedom of speech and expression. It's not an absolute fundamental right. So your fundamental right can be restricted on 8 grounds. Which are these 8 grounds? Sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, morality and decency, defamation, incitement to an offence, and what is the last one? Incitement to an offence, morality or decency, defamation, contempt of court is the 8th reasonable restriction on your freedom of speech and expression. Let's look at Article 29. Listen to me carefully. Article 29 does talk about protection of interest of minorities, but it doesn't say anything about the minorities. Who talks about minorities? Article 30. It is this Article 30 who says all minorities, whether based on language or religion, they have a fundamental right, which is to establish, manage, and administer educational institutions of their choice. To establish, manage, and administer educational institutions of your choice. But then what does Article 29 talk about? It talks about citizens. That means Article 29 and Article 30, these are exclusively available to citizens. Now it comes to another point. Which are the fundamental rights which are exclusively available to citizens? Which are these fundamental rights? Article 15, Article 16, Article 19, Article 29 and Article 30. These are the fundamental rights which are exclusively available to the citizens. And what Article 29 says? It says all citizens residing anywhere within the territory of India, if you have a distinct language, script, or culture of your own, and you want to preserve the script, language, or culture, that is your fundamental right. So that is Article 29. So Article 29, it starts with the title Protection of Interest of Minorities, but it doesn't talk about minorities. It says all citizens residing anywhere within the territory of India, if you have a distinct language, script, and culture of your own, and you want to preserve that culture, you have the fundamental right to conserve it. It is Article 30, which talks about all minorities, whether based on language or religion, which means our constitution recognizes minorities only on two grounds, language or religion. And if you are minority based on language or religion, you have a fundamental right, which is to administer, establish, and manage educational institutions of your choice. That is Article 32. That's Article 30. And Article 32 we discussed. Article 37. Application of the principles contained in this part. And which is this part? Part 4 of the Constitution. Part 4 deals with Directive Principles of State Policy. And Article 37 says, and it talks about two important characteristics of Directive Principles. Which are these two important characteristics of Directive Principles? One, these principles are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement them, because these directive principles are fundamental for the governance of the country. So Article 37, it talks about two important characteristics of directive principles. These principles contained in Part 4, these are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement them, because these DPSPs are fundamental for the governance of the country. Tribal populations' culture is preserved under which article? It's preserved under Article 29 of the Constitution. Writs include writ of habeas corpus, mandamus, prohibition, certiorari, quo warranto. Okay. Now there are two directive principles that you must remember. Questions have been asked previously, and I think this time the question may be asked related to Article 39 Clause B, because there is a petition pending in the court. I don't have to get into details of that petition because that would consume a lot of time, because here we are for a quick revision of all the articles of the Constitution. But I think if I was somebody who would make this question paper, I would ask about Article 39 Clause B. Because it's these two articles, 39B and 39 Clause C, which have primacy over Article 14 and 19. And also because Article 39 Clause B, this petition is pending before the court. Article 39 Clause B talks about the ownership. It's an obligation on the state, because all these DPSPs are obligations, positive limitations on the state, positive obligations on the state. That the ownership and the control of material resources of a community are so distributed so as to subserve the common good. Remember this directive principle, 39 Clause B. And 39 Clause C, that the operation, it's again a limitation, again a positive obligation on the state, that the operation of the economic system does not result in the concentration of wealth and means of production to a common detriment. So it should not result in the concentration of wealth in fewer hands. That's Article 39 Clause C. These two directive principles, please remember. Article 40, obligation on the state that you have to take steps to organize village panchayats and empower them with powers so as to enable them to function as units of rural, local self-government. Units of rural local self-government. That's under Article 40. Article 44, which is almost always in the news, it talks about uniform civil code for the citizens. Article 50, which talks about separation of executive from the judiciary or judiciary from the executive. Article 51, which imposes a positive obligation on the state that the state shall endeavor to promote international peace, to take steps to promote international peace and security, to ensure that as much as possible you're resolving conflict through arbitration. That's Article 51. These are part of the directive principles. And then we have Article 51 capital A, which talks about fundamental duties, which originally was not part of the Constitution. And this chapter, Part 4 capital A, was added by the 42nd Constitutional Amendment Act 1976 on the basis of the recommendations of Sardar Swaran Singh Committee, but not all the recommendations of Sardar Swaran Singh Committee were accepted. Some of them were accepted. Initially there were 10. Now there are 11 fundamental duties mentioned under Part 4 capital A of the Constitution. The last one was added. I will use a different color to highlight it. 86th Constitutional Amendment Act. Please make one short video of entire polity. Can't be covered in one short video. Or if you're saying one shot, even in that one short video, we can't cover it. But be that as it may, what are these fundamental duties? Abide by the Constitution, respect its ideals, national flag and the national anthem, to cherish and value and preserve the rich heritage of our composite culture, to uphold unity, integrity and sovereignty of India, to develop scientific temper, spirit of humanism, reform, to value and preserve the rich heritage of our composite culture, to render national service when called upon to do so, to let's say renounce the practices which are derogatory for the dignity of the woman. All these important fundamental duties. So please remember these fundamental duties, because sometimes the questions asked are which of the following are directive principles. So some of these directive principles, they match the wordings of fundamental duties. So which of the following are fundamental duties? Please remember and memorize these 11 fundamental duties. Article 52, which is the shortest article in the Constitution, it says there shall be a President of India. And the very next article talks about all the executive powers are vested of the Union are vested with the President of India. Article 61, it talks about impeachment of the President of India. And the President of India can be impeached on the grounds of violation of the Constitution. Unlike United States of America, no Indian president ever has been impeached. Donald Trump is the first American president to be impeached twice. Otherwise, previously, Bill Clinton, President Johnson, they have also been impeached. Sir, why you stop advertising about UCAN current affairs program? Is it stopped? Please, sir. It is not stopped. It's part of our course. Whoever enrolls in that course gets access to UCAN as well. Okay. Article 74. There shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall act on that advice, provided the President may ask for reconsideration of that advice. But if the same advice is given again, it's binding on the President to accept that advice. That is Article 74 of the Constitution. And Article 74 Clause 2 says that this advice cannot be inquired into any court of law. And Article 75, it talks about the Prime Minister shall be appointed by the President, and all the other ministers shall be appointed by the President on the advice of the Prime Minister. And the composition, the strength of the Council of Ministers, including the Prime Minister, shall not exceed how much? 15% of the Lok Sabha. That's Article 75. Article 79, it talks about Constitution of Parliament. Parliament consists of President, Parliament consists of Council of States, Parliament consists of House of the People. And it is slightly later that Hindi names were given to these houses. Council of States is known as the Rajya Sabha. House of the People known as the Lok Sabha. So Parliament consists of President, Rajya Sabha and Lok Sabha. Article 82, which gives a sense about delimitation exercise. After every census, upon the completion of every census, the allocation of seats in House of People and territorial constituencies are to be decided by Parliament by such authority and in such a manner as the Parliament may by law determine. That means who can carry out delimitation. It can be a delimitation commission. It can be the Election Commission of India as well. So it is for the Parliament to decide which authority, which manner will this delimitation exercise be carried out. That is mentioned where? Article 82. Since there is a lot of talk about delimitation in this country because of the perceived disadvantage of the southern states. If such a delimitation is carried out strictly according to the figures of the population, then southern states might be at a disadvantage as compared to the northern states. It might be as if you are penalizing the good performing southern states as opposed to the non-performing northern states. But be that as it may, whether that will happen or not, we don't know. But Article 82 talks about this readjustment after every census. But look at the last point. Provided that such readjustment shall not affect representation in the House of the People until the dissolution of the then existing House. So first the Lok Sabha has to be dissolved, and then this delimitation, the order of the delimitation can be implemented in that case. That's how the composition can change, which means even if it happens after 2026, the real impact we will see 2029. Clear? Or even after that, because it talks about Constitution was amended saying till 2026 there should be no delimitation, which means if at all delimitation is carried out, it can be carried out after that. And for that we have to wait for another census, and maybe the census will be conducted in 2031. So there are lots of permutations and combinations. Article 101, vacation of seats. You can't be the member of both the houses of the Parliament at the same time. You can't be the member of the Parliament as well as the member of the state legislature at the same time. Where is it mentioned? Article 101. Disqualifications also have been in the news. We have seen MPs getting disqualified. Where is that mentioned? That's mentioned under Article 102. Who can be disqualified? If you are holding an office of profit, if you have been declared mentally unsound, if you have been undischarged, insolvent, bankrupt, if there is a change in the nature of your citizenship. Why am I writing this? Because I'll tell you something else. Additional grounds of disqualification can be prescribed by Parliament. How? By law. What is this law? Representation of the People Act 1951. What is this law? 10th schedule of the Constitution. And we have discussed previously in the Conquer Prelims crash course as well, Section 8 Clause 1 of the Representation of the People Act, Section 8 Clause 2, Section 8 Clause 3, Section 8 Clause 4, which was declared unconstitutional by the court in a famous landmark Lily Thomas versus Union of India 2013. So, additional grounds of disqualification can be prescribed by Parliament by enacting a law. Clear? Article 105 also has been in the news. Why? Because the Supreme Court said taking bribe is not an immunity to be provided to the legislators. Basically, the old case, Narasimha Rao versus CBI, that has been overruled by the Supreme Court in Sita Soren case. But then we also saw issues surrounding powers, privileges when it comes to Prajwal Revana, who was the member of the parliament when he was accused of committing crimes. We saw this issue in the news because of the member of the parliament from West Bengal, what's her name? Maua Moitra. We saw these instances play up. So these powers, privileges, immunities, although they have not been codified, there is no law which codifies all these powers, privileges and immunities. But the strength that they draw is from Article 105. And if Article 105 is applicable to the parliamentarians, to Parliament as an institution, there is a similar power privilege available to the houses of the state legislatures and their members. And that's covered under Article 194. Long story short, Article 105 talks about powers, privileges and immunities of Parliament and its members. And Article 194 talks about powers, privileges, immunities of state legislatures and their members. Clear? Article 110 talks about definition of the money bill. A bill is a money bill if it deals with only the provisions that are mentioned under Article 110. So Article 110 deals with money bill. Article 111 talks about assent to bills. And what is this assent to bills? When a bill is passed by both houses of the Indian Parliament, sent to the President, what are the options available with the President? The President may give her assent. The President may withhold her assent. The President may send the bill back if it is not a money bill. These are the options available with the President under Article 111. Similar provisions are available to Governor under Article 200 of the Constitution. But now listen to me carefully. Something happened recently. Recently in a sense, that period which is relevant for your Prelims 2024, over the past 1.5 years. There is an additional power available with the governor of a state. Governor also can give his assent, withhold his assent, send the bill back if it is not a money bill, or may reserve a bill for the consideration of the President. And after that, the governor has no role. But, what the court has said, when a bill is passed by the state legislature, sent to the governor for assent, if the governor says, I am not going to sign this bill, if the governor publicly declares, I am withholding my assent to the bill, that does not mean this is the death of the bill. This is the end of this bill. This bill can never become a law. What the governor has to do after that? If you are publicly declaring that I'm not going to sign this bill, the governor has to send this bill back to the state legislature. And once this bill is given back to the state legislature, now if the state legislature decides to pass this bill again, it is binding on the governor to assent this bill. That is why I mentioned this together. Article 111, which talks about assent to bills, the power which is available with the President of India. And Article 200 available with the governor of a state. Article 112, because the term budget is not mentioned in the Constitution. Constitution refers to union budget under Article 112 as what? Annual financial statement. Where is it mentioned? Article 112. Article 117 talks about special provisions to financial bills. Both money bills and financial bills can be introduced only in the Lok Sabha, that too with the previous consent of the President of India, previous approval of the President of India. But on money bills, Rajya Sabha has no role or an inferior role, because Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can only make recommendations to a money bill. Or if Rajya Sabha does not act on this money bill for 14 days, the money bill shall be deemed to have been passed by both houses of the parliament. But in case of a financial bill, Rajya Sabha has an equal role. Equal role in the sense, yes, financial bill can be introduced only in the Lok Sabha. That too with the prior consent approval of the President. But after that, Rajya Sabha has the power to reject it. Rajya Sabha has the power to amend it. And if Rajya Sabha does not act on this financial bill for 6 months, then what happens in this case? There can be, not there shall be, because it's not mandatory, there may be a joint sitting of the two houses of the parliament. Now it is Article 123. Which talks about the President. Similarly, we have Article 213, which talks about the power of the governor. What is that? The power to promulgate an ordinance. If the President is satisfied that when either one or both houses of the parliament are not in session, then the President can promulgate an ordinance on all the powers, on all these subjects on which Parliament has the power to make laws. That means on any item mentioned in the union list, any item mentioned in the concurrent list, but ordinances cannot be used, or should we say cannot be promulgated to amend the Constitution. Clear? Can Parliament convert all states into union territory under Article 3 even though federalism is recognized as basic structure? This happened in case of Jammu and Kashmir, where the entire state was downgraded and converted into 2 union territories, bifurcated into union territories. Now whether Ladakh being converted into a union territory was valid or invalid, Supreme Court said it's valid. But on Jammu and Kashmir, the Supreme Court said we will not answer this question as of now, because we have got the assurance from the Solicitor General of India that the UT status for Jammu and Kashmir is not permanent. We are going to give back statehood to Jammu and Kashmir. So if it is not a permanent feature, then we will not decide on this matter right now whether this was right or wrong. Whether this judgment was right or wrong, that is for you to decide. It's as if today I am teaching you with all the passion that I have, and there's a knock at the door and the police comes and takes me away. Man, you are under arrest. All the students, because you also have the self-interest. Sir was teaching us good concepts for upcoming prelims. You will approach the court under Article 32. Habeas corpus. Show me the body of our polity teacher. And the Solicitor General will tell the Supreme Court, sir, this arrest is not permanent. We are going to release this polity teacher after the prelims exam, or maybe after some time. Will the court say, okay, since you have given the assurance, now it's not possible for us to comment whether this arrest was legal, illegal, justified, unjustified, moral, immoral, constitutional, unconstitutional, because you have said this is temporary. They're just keeping him under arrest for some days. We want to give him some food of the jail. It's nutritious. Clear? So whether that judgment was right or wrong, that is for people to decide. But be that as it may, Article 123 talks about the ordinance making power of the president. Article 213 talks about the ordinance making power of the governor. Finance bill versus financial bill. Finance bill is a money bill. Financial bill is not a money bill. Financial bill is money bill plus something else. So finance bill is a money bill. Okay. Article 124 talks about the establishment and constitution of the Supreme Court. There shall be a Supreme Court of India in Delhi. There shall be a Supreme Court consisting of Chief Justice of India and not more than 7 judges. That's how original constitution mentioned Article 124. But the number of judges can be increased. And who can increase the number of judges? Parliament. And for that, Parliament does not have to enact a constitutional amendment bill. Through an ordinary law, by simple majority, the Parliament can increase the number of judges. And Parliament has done that. So currently we have the Chief Justice of India and 33 other judges, also known as the puisne judges. But it is Article 124 Clause 2 which also talks about the appointment of judges to the Supreme Court. All these judges shall be appointed by the President. And you would know on the appointment of judges, there is a lot of controversy already. Since 1993, this power has been arrogated by the Supreme Court to itself, making India perhaps the only country in the world where judges are appointed by themselves. Although the formal appointment letter is issued by the President, but President does that on the recommendations of the collegium system. Although collegium system is nowhere mentioned in the Constitution. Okay, so that is Article 124, which talks about the establishment of the Supreme Court as well as the appointment of judges. Review petitions also have been in the news. Not just review petitions, we have seen curative petitions also in the news. But curative petition is something which is not mentioned in the Constitution. It was innovated by the Supreme Court in a famous Hurrah versus Hurrah case. But review petitions are mentioned under Article 137. Power of the Supreme Court to review its own judgments. That is mentioned. But curative petition is not mentioned. It's an innovation of the judiciary in 2000. Article 141, it says law declared by the Parliament to be binding on all courts. Which article of the Constitution mentions that the law declared by the Supreme Court is to be binding on all courts? Article 140, 141, 142, 143. You have to remember it is 141. Article 142, which has been invoked multiple times in this period of 1.5 to 2 years. It was invoked in the case of Delhi Metro. Reliance case. It was invoked in case of the election of the Chandigarh mayor. It was previously invoked in case of the Ayodhya Ram Janmabhoomi dispute case. It was also invoked in case of the Manipur MLA's defection. So many instances. So Article 142, where the Supreme Court alone has the power to issue any order, any judgment, so as to give complete justice. And then we have Article 143 of the Constitution, which is it visible? Yes, it is. Which is the advisory jurisdiction of the Supreme Court. power of the president to consult the Supreme Court. And this was also in the news in the last 1.5 to 2 years. So Article 143 becomes important. Article 148 talks about a constitutional body called Comptroller and the Auditor General of India. It says the CAG shall be appointed by the president by warrant under his hand and seal, and can be removed just like the judge of the Supreme Court is removed. So all that is mentioned under Article 148. Clear? So please tell me, how can I join your course? The link is provided in the description, or if you can see the pinned comment by Unacademy IAS English, you can click on that link and join the course. Article 153, Governors of States. The governor shall be appointed by the president. But it is this Article 153 which was amended via 7th Constitutional Amendment Act 1956, which says the same governor can be appointed to more than one state. That was not originally mentioned in the Constitution. That was added by the 7th Constitutional Amendment Act 1956. Clear? Since governors have been in the news, this can be important. Article 163 is similar to Article 74, but with some exception. There shall be Council of Ministers with the Chief Minister at the head to aid and advise the governor, who shall act on that advice except when the governor has to act in his discretion. That means when the governor has to act on his own without the aid and advice of the Chief Minister and Council of Ministers. And the same Constitution says, if at all there is a dispute as to what constitutes the discretionary power of the governor, the word of the governor shall be final. So the governor gets to decide what are my discretionary powers. Article 169, abolition or creation of legislative councils in India. Who has the power to abolish or create legislative councils in India? That power is with the Parliament. But Parliament cannot act on its own. Parliament has to act on the recommendations of the state legislature, of the state legislative assembly. Which means in, let's say, Tamil Nadu, where there is no legislative council, if the Tamil Nadu Legislative Assembly passes a resolution by special majority, urging the Parliament, requesting the Parliament that please create legislative council for Tamil Nadu, Parliament may or may not, which means this resolution, this recommendation by the state legislature is not binding on the Parliament. But who can abolish a legislative council? Who can establish a legislative council? That's covered under Article 169. That is the power available with the Parliament. Okay. Now, these are 4 important articles. Listen to me one by one. Maybe one of these can be asked in the exam. Have been asked previously as well, but you never know. Article 249, it gives power to the Rajya Sabha. It's a special power of the Rajya Sabha. If Rajya Sabha passes a resolution by 2/3 of the members present and voting and says that it is in national interest, then Parliament can make a law on state list. What is the validity of this law? 1 year. Can this law be extended further? Another 1 year based on the resolution of the Rajya Sabha. Long story short, which of the following articles of the Indian Constitution gives power or empowers the Rajya Sabha to empower the Parliament to make a law on any item mentioned in the state list in national interest? That is Article 249. And Article 250 talks about Parliament enjoying concurrent power of legislation when it comes to national emergency. What does that mean? Listen to me carefully. There is union list, state list, concurrent list. Who has the power to make a law on union list? Parliament. Who has the power to make a law on state list? State legislature. Who has the power to make a law on concurrent list? Both Parliament as well as state legislature. During national emergency, all the items in the state list, you can assume, are mentioned in the concurrent list. Which means on these items, both Parliament as well as state legislature has the power to make a law. This is what we call a centralizing tendency of Indian federalism. That is Article 250. Is it a special majority under Article 249? Yes. What is the discussion going on? Are you sure, subject to foregoing provisions of this article, a governor shall hold office for a term? If the discussion is on whether the term of the governor is mentioned in the constitution, yes, it is mentioned in the constitution. The term of the governor is for 5 years, subject to the, pleasure of the President of India. Clear? Okay. Article 252. If two or more, and Article 252 was also in the news, if two or more states request the Parliament to make a law on state list, these states will surrender that power to the Parliament. So under which of the following articles, two or more states can request the Parliament to make a law on state list? That is Article 252. And then we have Article 253, which empowers the Parliament that if you have to give effect, shape to an international agreement, treaty, then you can make a law, and that is under Article 253. For example, we ratified United Nations Convention Against Corruption in 2008, and basis that, Lokpal and Lokayukta bills were introduced in the Parliament under Article 253 because it was to give shape to an international agreement or treaty. That's Article 253. Article 262 talks about the adjudication of disputes related to interstate river water disputes or disputes related to the river valleys, through which you can also exclude the original jurisdiction of Supreme Court. That's Article 262. Article 263 says, if the President is satisfied, he can create an interstate council. And he did that in 1991. So which provision of the Indian Constitution talks about adjudication of interstate river water disputes? 262. Which provision of the Indian Constitution empowers the President to set up an interstate council? Article 263. Now, we have also seen dismissals of civil servants in some states. For example, in the Union Territory of Jammu and Kashmir as well. What is Article 311? If you are a member of the civil services, whether at the union level or at the All India service level or at the state level, or you're holding any civil service post, you cannot be removed by an authority which is inferior to the authority which appointed you. Which means if you were appointed by the governor, only the governor has the power to remove you. No other authority below governor has the power to remove you. And tomorrow, if you clear, and I'm sure all of you will clear the civil services exam, you'll be part of the bureaucracy, IAS, IPS, or a central civil service. You all will be appointed by the President. And Article 311 says you cannot be removed by an authority inferior to the one which appointed you. So if the President has appointed you, President has the power to remove you. In fact, if you are to be removed or dismissed or you're reduced in rank, there has to be an inquiry. You cannot be removed without an inquiry. But then you can be removed without an inquiry as well. Look at the steps. 1, you cannot be removed by an authority inferior to the one which appointed you. You're saying, yes, I'm safe. Then, you cannot be removed or reduced, your rank cannot be reduced or you cannot be dismissed without an inquiry. Now you're saying, yes. But even this inquiry is not required sometimes. When you are convicted, you are reduced, your rank is reduced or you're removed from service, you're dismissed from the service based on your conviction in a criminal case. The court has convicted you, you can be dismissed without an inquiry. Second, if the appointing authority, in the writing mentions the reasons why we can't hold the inquiry, then without holding the inquiry, you can be removed, dismissed, or your rank can be reduced. Or third instance, if the appointment authority or the removal authority, it says it is not possible to hold an inquiry because of national interest, then you can be removed, dismissed, or your rank can be reduced without holding an inquiry either. And that is how a lot of 40, 50, 60, according to newspaper reports, employees have been removed, dismissed without holding an inquiry. That's Article 311. Article 312 talks about All India services. Who can create a new All India service? This power is with the Parliament. But Parliament cannot initiate this on its own unless and until the Rajya Sabha passes a resolution. Only when the Rajya Sabha passes a resolution can Parliament enact a law and create a new All India service. But for that you need to understand, except an All India Judicial Service. Why? Because an All India Judicial Service has already been created, although it has not been notified, by the 42nd Constitutional Amendment Act 1976. Is this color visible? I think it is. Okay, great. Let's quickly jump to, and we are moving towards the end of this lecture. It's already been 75 minutes. Article 324 gives power, creates a constitutional body called Election Commission of India. And since Election Commission of India has been in the news because of how the chief election commissioners and election commissioners can be appointed, although the Supreme Court judgment in Anup Baranwal said you have to include Chief Justice of India as part of a committee to recommend to the President. But now this Chief Justice has been removed from that panel. Now a panel consisting of the Prime Minister, a Union Minister nominated by the Prime Minister, and the Leader of the Opposition in Lok Sabha will recommend to the President Chief Election Commissioners and the Election Commissioners. So that's Article 324. Article 343, it talks about official language of the Union. And according to the Constitution, what is the official language of the Union? Hindi in Devanagari script. But the Constitution further says that English, which was used, can continue to be used for 15 years since the commencement of the Constitution, which means till 1965. And if you have to use English as the official language of the Union, even after 1965, for that a law has to be passed. Who will pass this law? Parliament. And Parliament will pass this law by a simple majority. That means you don't have to amend the Constitution. And this is what you might have read. This is what lends flexibility to our Indian Constitution. Clear? Let's quickly look at these provisions. Article 352, if the President is satisfied because of the war, because of external aggression, because of armed rebellion, what the President can do, President can proclaim national emergency. President can proclaim national emergency even in anticipation of war, external aggression or armed rebellion. That's Article 352. Article 355 has been in the news because of Manipur. It shall be the duty of the Union to protect a state from external aggression, from internal disturbance as well. There is internal disturbance going on in Manipur, and you know the reasons. Although it appears that it's a fit case of President's rule, but President's rule has not been imposed. And that President's rule is mentioned under Article 356. If the President is satisfied on the basis of the report of the governor or even otherwise that there is a breakdown of constitutional machinery, then President can do, the President can impose President's rule in a state, and the first casualty is the Chief Minister and his Council of Ministers would be dismissed. That's President's rule under Article 356. Similar to that, you might be asked about Article 365. And under Article 365, directives can be issued to the states by the centre. And these directives are coercive in nature. That means if the state does not abide by these directives, then it can be viewed that there is breakdown of constitutional machinery. And then under Article 356, President's rule can be imposed in a state which is not abiding by the directives issued by the centre. And Article 360, which talks about provisions as to financial emergency. If the President is satisfied, when the financial system of the Union is under threat, when the financial credit or stability of the Union is under threat, the President can proclaim financial emergency. And once this financial emergency is proclaimed, then within 2 months, both houses of the Parliament shall have to approve this financial emergency by simple majority. And once both houses of the Parliament approve financial emergency by simple majority, then this financial emergency continues unless revoked by the President. And I don't have to tell you that all these emergencies can be imposed, although emergency is used only for Article 352, but all 352, 356, 360 can be imposed only on the advice of the Cabinet, not unilaterally by the President, because President is the quote-unquote rubber stamp. The last article of the session, Article 368, power of the Parliament to amend the Constitution and the procedure therefore. How the bill is to be introduced in the Parliament to amend the Constitution. How, if some federal features of the Constitution are to be amended, you need ratification by at least half of the states as well. If you are amending federal features, and that is Article 368 of the Constitution. Which of the following articles of the Indian Constitution empowers the Parliament to amend the Constitution subject to basic structure? Because even by using Article 368, Parliament can dare not amend, violate, abridge, delete, modify the provisions which are part of the basic structure of the Indian Constitution. That is Article 368. That brings us to the end of this session, where in one article we covered almost all the important articles of the Indian Constitution. All the important articles, every article is important, otherwise it would not have been part of the Constitution. But all the important articles are relevant for the upcoming Prelims 2024. That is it. Tomorrow, 7 o'clock, we will come up with all the important constitutional amendments since 1951 till as recent as 2023. We'll cover all these important constitutional amendments in one class, and then we will wish you luck for the upcoming prelims. Thank you for staying with me. Don't panic. Don't worry. You will crack it. Let's crack it. Good night.